Assalamu alaikum, dear students. Today's topic is for class 11th, and we shall discuss today higher number of amendments, circumstances, and controversies. Dear students, as we know that about more than 100 amendments have been made in the Indian Constitution. There are various these amendments are of various nature. Firstly, we shall see the amendments of technical and administrative nature. Several amendments have been passed because of purely technical and administrative reasons and have come in the form of minor clarification and modifications. These amendments are only legislative provisions and make no substantial difference to the existing provisions. These may include the 15th Amendment 1963, which increased the age of retirement of High Court judges from 60 to 62 years. Number second, differing interpretations between judiciary and legislature. Dear students, a number of amendments in the Indian Constitution came up due to differing interpretations of legislature and judiciary. And whenever there was a conflict between the legislature and judiciary, the parliament inserted an amendment to make its interpretation authentic. In a democracy, different institutions may interpret the laws variously. At times, the parliament may not argue with judiciary and therefore it amends the constitution. Such amendments include disputes over the relationship between directive principles and fundamental rights, right to private property, and the parliament's power to amend the constitution. First Amendment in 1951 was regarding right to property. This led to an amendment where Schedule 9th was inserted to implement the validity of Zamindari abolition and the other Land Reforms Act. In Golknath case in 1967, the Supreme Court ruled that the Parliament had no power to abridge fundamental rights. The 24th Amendment of 1971 set aside all doubts regarding the Parliament's power to amend the Constitution. Number third, amendment is based on political consensus. Dear students, a large number of amendments in India have been based on consensus. They highlight the political philosophy and aspirations of society. These may include 52 Amendment 1985, which provided that if a member of parliament or state legislature defected from his party, he would be disqualified. Likewise, the 62nd Amendment reduced voting from age 21 to 18 years. Number fourth are the controversial amendments. The 38th, 39th and the 42nd Amendments in the wake of internal emergency in 1975 were the most controversial amendments as they sought to alter the basic structure of the Constitution. The 38th Amendment made declaration of national emergency non-justiciable. The 1839th Amendment provided that disputes related to election of president, vice president, prime minister, and speaker would be decided by an authority determined by parliament. They were placed beyond judicial scrutiny. Moreover, the 42nd Amendment was the most controversial and marginalized the autonomy of the several institutions. In 1977, elections were held and Congress was swept out of power. Dear students, these were the amendments of various natures. We saw the amendments of technical and administrative nature, differing interpretations between judiciary and legislature, amendments based on political consensus, and controversial amendments. This was today's topic. That is all. Okay.